and I'll work on keeping my aura of being in control. But moving on, we've got, a facilitated discussion that will be facilitated by yourself, and we've got that for the next 15 minutes. And then as we are running a little bit behind time, we will direct all questions to the speakers just to the discussion space. So we'll miss out on lunch.
Who's got some questions for any of our panellists?
Everyone, how does the government monitor the, like all the environmental representations? I mean, you rely on the government to convey that. Is there sort of overall accepted view?
I think third-party rights, so that means allowing people to bring proceedings and be involved in environmental decision-making is really important to hold, because to hold government to account, because government is primarily in charge of environmental regulation, but it doesn't always do a brilliant job. So having people who are familiar with environments and they can see what's happening and know what's going on, and giving those people a right to participate in decision-making is really important.
You said the VCAT says that they're not obliged to, it's not their job to monitor pollution. You said that when
I think I said it wasn't one of the arguments was that it wasn't VCAT's job to ensure that that particular emissions reduction target was complied with, because the legislation says that that's the minister's responsibility. So, I mean, it's still the Environment Minister's responsibility, and I suppose it's still the role of everybody to try and participate, to hold into account, to ensure that that target's met. But it's not as simple as we can just go off to court and take the minister to the environment and just say, you're not meeting the target.
The courts don't do it. You sort of wonder, where it's been.
The courts have a role in that, and VCAT has a role in that, but it's just sometimes it's not as straightforward as saying the Minister for Environment has to do that, therefore the EPA has to do that. It's just, because of that particular law, it's a bit more complicated, but sometimes it's quite straightforward. There was a recent case against Vic Forests that was successful because, sorry, this microphone's a bit, I hope it's not too painful. Basically, an environment group took Vic Forests, which are the government body that's sort of in charge of forestry in Victoria and the commercial aspects primarily, and they took them to court saying you're not complying with your duty to ensure that threatened species aren't unduly harmed, and the court found that they weren't complying with that legal duty, and therefore Vic Forests had to basically comply with that duty. So the courts do have an important role, and if third parties and environmentally concerned citizens can access those forums, then that's one way you can hold government to account.
Apparently I'm also meant to ask that whether the panellists have questions of each other. They're not very responsive, are they? Well, I have one question, which is actually arose from a question that was addressed to Justice Kirby, and that was the, which comes into the wild law sort of aspect. It had a particular animal rights focus, which I find very speciest, but because it only deals with sentient animals rather than 99% of the rest of the world's biota. But what would your answer to that sort of question be as to whether we should only be focusing on the sort of animal welfare as opposed to changing the ideologies of the law in relation to concepts of property and personhood?
Yeah. I guess for
Yeah, that's good. And just keep it 6 inches away from you.
Okay, that is. I think for pragmatic reasons, I quite agreed with his response. And in terms of achieving immediate outcomes for political reasons, that seems not a unsensible suggestion. More broadly, though, I think it's hugely problematic just to have that narrow a focus. As you say, the vast majority of the natural world is made up of beings which don't have that sentience. I think one of the issues of how you address that, though, is maybe not necessarily through a rights discourse. I think in countries where that works, it's a fine and valuable thing. In a country like Australia, where we struggle with notions of human rights, maybe that line of thinking is much harder to sell. So in terms of how you get to a point of protecting nature more broadly than sentient species, I'm quite interested in the idea of us having duties toward nature. I mean, rights, duties are often seen as having correlation, existing in relationship to each other. If the language of duties is more palatable to an Australian audience or to other audiences, I find that a very valuable way of approaching it.
More questions? Yes?
My question's for Peter Burton. Do you think we'll ever see a constitutional amendment like Ecuador's?
In Australia?
Yeah.
I was asked that question a little while ago in the context of, okay, my answer is no, not without a massive community push for it. Not in and of itself. It's not going to happen automatically. It's not a given. Unless there is a massive grassroots community push for a change of that kind, no chance. If there is, then I would consider it possible. So I think one of the questions with the Ecuador situation is, unless a community really understands and embodies concepts like rights, you can have nice language in a constitution, but it may not have any effect. It may not change the way people behave because they don't have, in a sense, an ownership of the concept. But if it's driven from the bottom up, and if people have ownership of an idea, then its consequence in the end is much greater. So I think it's unlikely to happen without a community push for it, a massive community push for it, and I think that is more desirable than it occurring just as a legislative amendment, which might end up being a tokenistic gesture rather than something that is concrete and has teeth, has effect.
Questions? Yes, we'll take one at the back there. Yes, thank you.
I was just wondering whether you had a good example of it in your book that you were talking about. You mentioned that some environmental cases, if you're arguing for against some tiny species that no one's heard about, that it would be quite hard to find that kind of noise from your experience. Have you had something like?
Yes, well, a number of the species that end up in court are rather non-charismatic. Sort of the Cumberland Plains snail, for example, is, you can't really dress up in Martin Place and rattle a bucket and say the snails.